those will join. Some others will join, or otherwise we will put the interview video on our websites, on the social media, and they can afterwards can watch and can make other comments on this interview. Again, I would like to mention that this online event is organized under the GIAC Arbitration Days 2021, which has been very successfully launched last evening, where we had the very nice and warm opening remarks from our sponsors, from the Ministry of Justice, and also we have very interesting and exciting keynote speech from Mr. Eduardo Silva Romero, and I think that who couldn't manage to attend this event, they can watch the video on our social medias. Now, I would like to open this very interesting online event, which we'll call it interview, and it is kind of a continuation of the interview series what we have started last year during the very strict COVID times. Actually, this is the non-usual format for us, that we have the hybrid format, and other online events will be organized after this event during the December. And in this interview, we have a special guest, and we are proud of this, and it is really privileged to have the Professor Bernard Hanotiau. I am sure that most of you know this name, and especially International Arbitration Society in the world. He is one of the well-known arbitrator and practitioner in international arbitration, and there is many words can be said about him, but I can just mention that he has more than 500 international arbitration involvements, and is a professor of different universities. His specialties is and author of the books, articles, and he's known for his complex arbitration issues. And I'm sure this evening and afternoon, maybe we will hear some comments and the observations from him. And I'm sure that this event will be very interesting. From the other side, side of the interviewer, we have Michele Potestà. I think that it should be underlined that he is one of the new generation practitioner in international arbitration. He's partner in Levy Kaufman Kohler, based in Geneva. Already managed to participate in more than 40 arbitration proceedings involving investor state disputes in different institutions. And also I have to mention he's very actively participating in UNCITRAL sessions under the working group 3, where the investment state dispute settlement reform is discussed, and he is representing Swiss delegation. Now, Michele, I would like to give you a online floor, and wish you a very nice interview with Professor. Thank you very much for this short introduction. Sorry.
Thank you very much, Becca, and thanks to you and the GIAC for inviting me and for this very nice opportunity to pose some questions to Professor Hanotiau, and thanks also from my part to him for being here. I would just like to kick off with a question on ethics of arbitrators. As Becca said, both him and I were last week in the UNCITRAL Working Group 3 sessions in different delegations, and there was a 1-week discussion on the so-called code of conduct for arbitrators, which is a very topical top issue in investor state arbitration. And I wanted to ask a question to Professor Hanotiau, because he submitted comments in his personal capacity to some of the earlier versions of the code. And so I would like to ask you you were quite critical of some of the provisions in the code, and you wrote that it seemed to you that the code was inspired by distrust of the sentiment of distrust of the arbitration process and international arbitrators. So I would like to ask you, what aspects were of most concern to you, and do you believe the subsequent versions of the code have alleviated your concern or perhaps made them worse?
Yeah, well, my main concern relates to Article 10, disclosure obligations. I consider it's much too broad. So they say that arbitrators have to disclose, well, that's normal to disclose any interest, relationship of matter that may, in the eyes of the disputed parties, give rise to doubts as to their independence and impartiality. But paragraph 2 says that it shall include the following information in their disclosures: any financial, business, professional, personal relationship within the past 10 years with the disputing parties, any subsidiary, affiliate, parent company, state agency, state-owned enterprise, legal representative, the other arbitrators, expert witnesses, a third-party funder during a period of 10 years. This is unreasonable, absolutely, and unmanageable. I discussed with other arbitrators, this is not reasonable. First, I think that the criterion should be the reasonable man. But you know, we know today that there is a lot of paranoia in some parts of the world. If you have, for example, if you are appointed arbitrator in California, you receive 2 or 3 pages letters of questions concerning yourself, your relationship with others, and so on. It goes really too far. And the problem is that, you know, the parties are very sophisticated, and from the beginning they make investigations and they try to find what could be found that could be used against you in case they lose the they lose the case. So and a period of the 10 years is really totally unreasonable.
Yeah, do you think these kind of provision will encourage more challenges, as you said, perhaps to the award, also perhaps more challenges against the arbitrators?
Yes, I wrote to McKinney that I think that they are offering on a golden plate the possibility to challenge awards. Because, you know, as I said, nowadays, parties from the beginning of the arbitration, they try to already gather information, and sometimes, you know, just ridiculous thing, but they try to gather this, and the day they lose, they will start or before, not only they will start a challenge if they don't like the arbitrator, but they will try later to obtain the annulment of the award on the basis of non-disclosure.
It may come perhaps as a relief to you, or maybe not, but the negotiations on this particular provisions did not yet reach the stage of the discussions because there was not sufficient time. So they are postponed to some later period. Is not totally clear when, but perhaps some of the concerns that you've raised will be taken into account. Of course, the difficulty, I guess, would be how to combine these kind of concern on realism, as you've said, with the desire for more transparency that we hear more and more from states and other stakeholders. But let's see how this will come along. One issue that was discussed very vehemently, I would say, this week, last week at the Ulster Working Group 3, was the issue of double heading and multiple roles, counsel and arbitrator especially. And I know that your firm has decided already some years ago not to engage or to not engage in so-called double heading. Why is this so? And so do you think double heading should be prohibited?
I think, well, this is the position we have taken, and I think that double heading should be prohibited. Of course, there are pros and cons. For example, young lawyers say, but how can I get experience and later be appointed in an investment arbitration if I cannot participate in a team as advocates? Okay, I understand this concern. On the other hand, it is true that double hatting is dangerous because you are counsel in one case and you have an issue of, a very specific issue of, let's say, expropriation of fair equitable treatments, a very specific one. You have exactly the same specific issue in a case where you are arbitrator. Could be said that, you are trying to promote a certain position when you decide the case as arbitrator in order to have a better chance to win in your counsel case. Also, from the point of view of the responsibility of the arbitrators, I think it is double hatting is very dangerous. I remember a case, I would say some 10, 15 years ago, where an arbitrator was arbitrator in a case where there was an issue of counterclaim. Is a counterclaim admissible in investment arbitration? And he had also a counsel case involving the same issue. And the counterclaim was rejected, and and it was the same position that the counsel defended in his counsel case. And at one point, the losing party in the arbitration was considering to start a case based on fraud. So, double hatting raises a lot of issues, but also an issue of responsibility for the arbitrators.
Yeah, that's so interesting, and the concern that the different concerns that you have highlighted came up also in a similar way during the discussions. And so again, there was no consensus reached on this point, and some delegations highlighted the need, as you said, to allow new entrants to come into the pool, because diversity is of course an issue, and at some point the older ones will retire, and how do you allow the younger ones to become arbitrators if they have not had the necessary experience? On the other hand, other delegations were really highlighting this danger that you are underscoring, of being at the same time an adjudicator on the same or similar legal issue, and also an advocate. And we know that in investment arbitration that the issues are so recurrent that it's really difficult to sometimes make a separation. So let's see where the discussion will lead us. Probably the most controversial topic. I want to take a step back and ask you some personal questions on your career, if you allow me. And I would like to ask you about your personal trajectory in terms of profession. How did you become interested in international arbitration? And what do you think were the key milestones in your career that really, launched it at such a wonderful level?
Yes, let me say first, before starting, that that this is a question that is asked very often. Well, you see the young lawyers impatient of making career in international arbitration, and I don't think it is. In most cases, it is very difficult to become an arbitrator, recurrent in many cases, before age 40, 42, 43. So I think first thing, you have to be patient. Well, as far as I'm concerned, I started my career as assistant professor in private international law at the University of Louvain in Belgium. At that time, there was no course on international arbitration. It was not taught. And I remember that, through various contacts, I was asked whether I would be interested in arbitration. So I discovered what it is. And once, it's very bizarre, but so I discovered what was international arbitration. And yes, two things. First, through the university, I was asked to become member of committees in the International Business Law Journal, which is a French law journal, which was very popular at that time. There were not many. Was edited by Henri Aiguillon, and Henri asked me to be the contact with the ICC. So, well, I had a footstep in the ICC. Then in 1980, the Brussels Bar Association organized a trip to the People's Republic of China, and I was able to be member of this group. And I was on my own, and the president of CEPANI, the Belgian Arbitration Center, was also on his own, and very often we were sharing the same room. When I came back, I was 32, I think. I got my first appointments. Well, so, sometimes there are some hazards. You have to catch them when they come. And then, I found that it was a very, very interesting. I became also professor at the University of Louvain at the Center of International Law. And I started publishing on arbitration, participating in conferences and so on. And that's how it started. But again, I got an appointment from time to time, but my career really started when I was around 42, 43.
Thank you. This leads me to my next question, which is, what tips would you give to younger lawyers looking for a way to break in their career? And you already gave one, which, if I can summarize, is stay calm and be patient, or at least not being too impatient. But what other tips would you like to give to young lawyers? What would really make the difference for them in order to stand out, given that the market is so much more competitive, I guess, than it used to be some decades ago?
Yes, it was very easy at my time. On the other hand, there were very few arbitrations. It was really limited to some countries in Europe, mainly Switzerland, France. Well, yes, of course, be patient. Also, yes, try to work in a law firm where you will be involved in international arbitration. Try to, if you have time, try to publish, and if you publish on substantive issues rather than procedural issues, and try to find issues, it's not easy, where there is where there are less contribution, less writings than in others. Attend conferences, you must be present. Even at my age, you must be present all the time, otherwise people forget you. And also, one very, very, very important advice: networking. Consider, if you are a young guy, that the people of your age who are also interested in international arbitration are not your competitors. They are the people who are going to appoint you in cases when the time will come. And so networking is very important. Try to have a network of friends, colleagues, people who progressively will have confidence in you and finally will appoint you when the time comes.
Mm-hmm. Yeah, this is very wise advice. Now, the question I had when listening to you is, how do we network in these times of pandemic? Where
yes, yes.
How have you been networking since you say that?
But on the other hand, well, of course, as far as I'm concerned, I've never been involved in so many webinars, so it's easier for me, certainly. No, it's I realize it's not so easy, but there are a lot of events organized by the young arbitrators in various countries. So I think networking is still possible. And finally, you see that the various social networks are working very, very well. You have a lot of information every day and a lot, of communication. So yes, I think it's a different networking, but
yeah, the opportunities are certainly there.
Yeah.
You're one of the busiest arbitrators worldwide. I assume to manage your busy workload, you rely on help from younger colleagues and the team. So my question was, what kind of qualities and qualifications do you look for when you're hiring a younger associate, for instance?
Well, in fact, you know, I have a team of various nationalities, people speaking various languages, always English, of course, but also they have a total command of English and French, Spanish, other languages, and always people who are, you know, the best of the class, and people who have also an advanced degree in international arbitration. And in fact, all the people I recruit nowadays are people who have done the MITS in Geneva, because I think it's the best school at the moment. There are others in England, in France, but I think that MITS is really, well, they're very, very selective in the recruitment. And also you get a lot of feedback when you are looking for new entrants in your firm. But I think, you know, my experience is there you have really the best candidates.
That's very important for us to hear. It's really great for us to hear. I'm sure also Becca, who is a MITS alum, will be particularly pleased to hear it, and I am personally as well. Now, moving on.
Actually, to... I proved that, and thank you.
I can imagine. I do too. But of course, we are not entirely.
You have also a moment there.
Yes, and we're not entirely impartial, but it's good to hear that Professor Hanotiau thinks that. Moving to some more issues of substance, Becca in his introduction mentioned your work on multi-party arbitration. You're I would say the world leading authority on that topic, and your second edition of your treatise of your book was published last year and spans now over 600 pages. Now, what prompted your interest in this difficult topic?
Well, you know, multi-party arbitration has been discussed for a very long time. And I remember, but a long time ago, the International Law Association set up a committee on multi-party, multi-contract arbitration. Horacio Grigeranan was the chair. And I found the topic extremely interesting. And so I started gathering cases, legislations, and so on, started to write articles on various aspects of the topic, which I still find very, very challenging. It's a sort of puzzle, you know. I have a case at the moment, which is probably one of the most complicated I have. And it's always very challenging, very interesting. And so I started publishing various you know, make various publications on various aspects of the topic. And then I published in 1999 a very long 95 pages article in the Journal of International Arbitration. And from there, at one point in 2004, you know, sometimes in your career, even if you are a busy arbitrator, you have 3 months without hearing. It happens to me on a regular basis. And, you know, I had this in 2004, and I decided to write a book. And I published so many things that I could make the first edition. And then I started gathering cases and all kinds of information for the second edition. I said, shall I be able to do it? And finally, one day I said, okay, I do it. And so there is, here is the second edition. I don't know if there is going to be a third edition. I think that my wife and my secretary are not terribly keen for that because they have suffered a lot. But I can assure you that I have already, well, 3 times that big, you know, that big information with new cases. You know, it's endless.
Yeah, that's right. I mean, there's never a dearth of interesting cases that come up in multi-party arbitration, whether this is in commercial arbitration or investment arbitration. And actually, do you see any difference, any fundamental differences in the two fields as far as multi-party arbitration is concerned?
Yes, well, there are less issues of multi-party in investment arbitration. You have issues of consolidations, definitely. 2-3 years ago, I was sitting in a case where we had two cases which were not formally consolidated, but which were held together with the wing persons being the same and two chairmen. So it happens from time to time, but it's mainly in commercial arbitration that you have most issues of multi-contract, multi-party, and you have a lot of them nowadays. I think that more than 1/3 of international arbitration are multi-party or multi-contract. But the difference, of course, between investment arbitration and commercial arbitration is that commercial arbitration is really very factual. Investment arbitration is more, the law, although there is an aspect of fact, but it's more the issues are more legal issues than factual issues.
Mm-hmm. That's right. Now, sort of related to multi-party, although it's slightly a different issue, of course, but it's an intriguing question which courts and commentators have been really grappling with for many years, is that regarding the law applicable to the arbitration agreement, in particular when it comes to the difficult issue of extending an arbitration agreement to a party that is a non-signatory to the arbitration agreement. And there is, of course, this very recent judgment handed down by the UK Supreme Court in Kababji Sal, which still highlights that there are important differences on this topic in various jurisdictions, and in particular in two very important arbitration jurisdictions, France and England. And so my question is, do you think we will ever see a uniformity in approaches on this issue, or is it time for the parties to simply say in their arbitration agreement what law applies to the arbitration agreement, although that's very rarely done as far as I know?
Yes, well, for those who are not familiar with the case, so it was a case where a Lebanese group granted a license to operate restaurants outlet in Kuwait to a company called Al-Oiz. And this company became a subsidiary of another company, which by name of Cult. And when a dispute arose, the Lebanese claimant started the arbitration not against the Al-Oiz, with whom they had contracted, but with the parent company. And and the contract provided that it was governed by English law, and the seat of the arbitration was in Paris. And the issue was whether Cult, non-signatory, was a party to the arbitration agreement. What law was applicable? The majority decided that since there was no provision saying that the arbitration agreement itself was governed by a specific rule, they applied the law of the seat, which was France, and they decided that according to French law, Cult was a party to the arbitration agreement. And there was an action to annul the award in France, and it was unsuccessful. But in England, there was an attempt to enforce the award. Enforcement was refused because the court said, well, the contract provides for English law, and therefore English law also governs the arbitration agreement. Let me say that I was surprised by the French decision. I don't know, of course, all the details of that French decision, but applying the law of the sea to the arbitration agreement for me is an outdated approach. Normally, it's the law which governs the contract itself. The problem for me is not really that. The problem is the approach to the extension of an arbitration agreement to a non-signatory. You know that the French have a very liberal approach based on the conduct, so implied consent, the conduct of the parties, and this is not accepted in England. You have the Peterson Farms case, which is one of the leading cases. No, it's not accepted in England. In England, there have to be an express consent. I must say, on the other hand, that there's always been antagonism between French judges and English judges. English judges consider they have the best legal system in the world, and that the French are much too liberal. And I think the reverse is also true.
There might be some cultural issues at stake, not just only legal. Thanks for these insights. When one thinks of multiple parties in commercial arbitration, one of the first things that certainly comes to mind is the famous Datco case. And maybe it would be, if for the younger audience that may not be familiar with the case, why is it so important, and what remains of in terms of legacy of this case today?
Yes, so Dutco was ICC case number 4131 of 1982. So it's a case which is 40 years old, but it was the first case where there was the first meaningful case in which there was an extension of an arbitration clause to a non-signatory claimants company, two claimants company. In fact, Dutco had the group of Dutco and several companies within the Dutco group had entered into contracts with a French company, and the dispute arose, and 4 companies of the Dutco group started an arbitration against the French company. 2 of them were non-signatories, and so the issue arose whether they were party indeed. They could be considered party to the arbitration agreement. And there is a very famous part of the award that I'm going to read, which says that considering that irrespective of the distinct juridical identity of each of its members, a group of companies constitutes one and the same economic reality of which the arbitral tribunal should take account when it rules on its own jurisdiction, considering in particular that the arbitration clause expressly accepted by certain of the companies of the group should bind the other companies which by virtue of their role in the conclusion, performance, or termination of the contracts containing said clauses, and in accordance with the mutual intention of the parties to the proceedings, appear to have been veritable parties to these contracts, or to have been principally concerned by them and the disputes to which they may give rise. So it says this is the beginning of this approach of French law, that in order for a company or an individual also to be considered party to the arbitration agreement, you don't need an agreement in writing. The conduct can be also evidence of the participation of the adherence to the arbitration clause. So in fact, the legacy of Dutco is first that the question of extension of an arbitration clause to a non-signatory should be decided by application of a substantive rule of international arbitration law, and that the consent to arbitrate can be implied from the conduct of a non-signatory through the role to the effective role it has played in the negotiation, performance, and or termination of the agreement. And when a company or group of companies is involved, the legacy is that the issue of consent to arbitration may take a special dimension when one or more companies to a complex international transaction are members of a group of companies, given the nature of the relationship which exists between these companies. And in particular, and I will finish by that, consent to arbitrate may sometimes be implied from the conduct of a company within the group, although it did not sign the arbitration agreement, and so by reason of its effective implication in the negotiation and or performance and or termination of the agreement containing the arbitration clause and to which one or more members of the group are a party. And this is the difference between with the British, which do not accept that.
Right. Still on multi-party arbitration, one issue that the multi-party arbitration poses among many is how do you appoint an arbitral tribunal, for instance, when there are 3 or 4 members of a consortium, and you are therefore outside of the usual constellation where claimant appoints an arbitrator and respondent appoints another arbitrator, and then there is some different method for appointing the chair. And so, for instance, if the interests of the various parties are not aligned, now some arbitral rules provide that the to guarantee this kind of equality of the parties among all of the participants, that actually no party gets to appoint their arbitrator, and the institution appoints all of the arbitrators. And I think this is a rule that is included in the ICC rules and other rules. And do you think there is scope for this rule, that is to say, a more important role for the appointment by the institution rather than the disputing parties beyond multi-party arbitration? And I'm asking this question because there is a debate within the arbitration community whether we should get rid essentially of party appointed arbitrators because they are allegedly not that impartial. Paulson has spoken of a moral hazard. Your partner, Professor Vandenberg, has published a study on party appointed arbitrators in investment arbitration, where he shows that they always dissent in favor of the party that appointed them. So what do you think of this entire debate? Is it time to get rid of party appointed arbitrators?
I'm absolutely against that, because I think that the one of the fundamental features of international arbitration is the possibility for a party to appoint his arbitrator based on his competence, his experience, the confidence they have in this person, this knowledge of the language, his knowledge of the industry. It is true, I've been on tribunals which have been totally appointed by an institution, and it worked very well, but I have other bad experience of appointments by an institution. And, in some institutions, also they tend to appoint friends or friends of friends. So I don't think you're going to resolve the problem of impartiality with the appointment of the 3 arbitrators by the institution. Also, you have cultural differences. I'm not going to mention names, but mention states, but there are some communities in the world where each time an arbitrator is appointed in that state is always, I would say, relatively partial. It is cultural. So I don't think that the appointment of the 3 members of the tribunal by an institution would be the solution. I think it is a fundamental principle of international arbitration that arbitrators should be appointed by the parties. And my experience, at least in commercial arbitration, well, there are some people who are less independent, but not so many, and they are known. They are known. We can, if you are experienced in international arbitration, you know who they are.
And when you, sorry, no, didn't.
No, go ahead. Yeah.
No, and just picking up on this last thought, if you know that someone is not, let's say, totally impartial, and you're chairing the tribunal, how do you manage this situation? Do you take any specific measures, at least in your mind, or how do you deal with that?
Yes, first, if the conduct of that person is not reasonable, you have to intervene. And I've seen cases like this, an English arbitrator being really showing partiality vis-a-vis one of the parties, and the chair finally decided to tell him, you have to stop this. But this is very rare. But yes, sometimes you realize that one of your arbitrators is not independent. Generally, the 3rd arbitrator, we also realize that, and of course, so we take that into consideration in our approach.
Mm-hmm. And still speaking of this, do you see a lot of dissenting opinions or concurring opinions in your cases? Do you actually dissent, or in some cases, or is it your policy not to?
Nowadays, because I started in 1978, nowadays I've been involved in various qualities in 620 arbitrations. I have dissented twice in commercial cases because, very honestly, I could not accept the decision. Well, it was really fundamental, because otherwise I would not have dissented. Sometimes there is one point on which you do not agree, there is a footnote, or you say, well, the majority has decided this, one arbitrator considered than this. So I think you should avoid dissent. So I have just dissented in 2 cases, never in investment arbitration. And I must say that, you know, I've done some, I think 60 or 70 investment arbitration cases. And in fact, very honestly, the dissents that I have seen were reasonable dissents. There are points on which you can disagree. And, you know, one point, is it admissibility, is it jurisdiction, or, you know, things like that. And I must say that all the dissents I have seen were reasonable dissent. It's not, doesn't mean by that that all dissents are reasonable, but and you know, the fact that many of them are done by the people who have been appointed by the losing party does not necessarily say that this person was partial, because there are people who are very often appointed by states. I sit with them, I don't find them partial. They just have a different approach to the problems than somebody who is, you know, who doesn't have this inclination. I must say that once a lawyer made a very good compliment to one of my associates, saying that he did not appoint me because he didn't know whether I was in favor of state or in favor of investors.
That's a great compliment, I guess. So we have, I had written in the chat that the audience should feel free to write their questions in the chat box or in the Q&A box. So feel free to write any question that you have for Professor Hanotiau. We have already one, and I'd like to ask it at this point, since we've discussed issues of applicable law and arbitration agreement. And the person asks a question about the applicable law issues in international commercial arbitration. He or she says it is very common for the parties to choose the law applicable to the main contract, but not to the arbitration agreement, as we've said. And then, so the question is, if the governing law of the main contract in itself consists of the CISG, the International Sale of Good Convention, what is your opinion regarding having the CISG as an applicable law for the arbitration agreement as well?
Well, I've never seen that. What I've seen is, you know, for example, the parties decide to apply Swiss law, and they either say we at the exception of the CISG. I've never ever seen a case where the party said the applicable law is the CISG. If it is the case, then of course you have a problem to determine what is the law governing the arbitration agreement, and then you have to have the normal approach of any arbitrator confronted to this problem, where there is no law governing the arbitration generally. Right.
It's also my experience that it's more often that you see the CISGs being excluded. Than where it is applied. But yeah, nonetheless, an interesting question, perhaps to be further thought about for publications or whatever. Now, moving to our last line of questions, if I can call them like this, which I wanted to focus a bit on arbitration and efficiency. Do you think the impact of the COVID-19 pandemic on case management will bring more efficient arbitrations also in the future, when we hope at some point we will have the pandemic behind us?
Yeah, one day. Well, yes. For example, to give a very simple example, in the past, when you had an exit arbitration, they insisted on an in-person management conference. So you had to travel to Washington and back for a 2 hours hearing. That's not going to happen anymore. So this kind of, you know, the case management conferences, in many cases, if the persons are not in the same city, will not take place in person, but will take place virtually. or if you have a very short jurisdictional hearing without witnesses, I suppose it will take place also by video. But beyond that, I think that most parties still want to have an in-person hearing. I see that now that frontiers are opening, parties like to have in-person hearings, and I think that it will continue that way in all reasonably normal arbitrations. If it is a very small case, might be different, but I think that in-person hearing will continue.
Mm-hmm. Yeah, we have a question from the audience. Tamar asks, "What is your experience with MedArb, which is this process that combines both mediation and arbitrations for those of the audience that are not familiar with that? And what would you consider as pros and cons of this combination of dispute resolution mechanism?"
So, in fact, the situation is where in the arbitration clause it is said that the parties must first enter into mediation, and if it is not successful, go to arbitration. Well, let me make two remarks. First, I think that mediation should not be decided in the arbitration clause. It should be decided when the dispute arises, because I have seen so many cases where indeed the parties had agreed to mediation, and so they started mediation. They lost a lot of time, cost a lot of money, and then they started arbitration. So I think that mediation means that the parties want to mediate, and so the decision should be taken when the dispute arises. As I said, I've had various experiences where finally it was a duplication of cost and a duplication of time.
Mm-hmm. Have you ever acted yourself as mediator?
Yes. Conciliator, yes.
Conciliator.
Still recently, I was appointed conciliator very recently, sole conciliator. It's not easy. It's not easy, and I must say that in all cases in which I have been involved, and generally with 3 people, it has not been successful.
Do you think it requires a different skill than being an arbitrator?
I think that if you have special skills, it can work. Let me give you one example. I had a case 15 years ago where when we arrived, well, I was sitting with one of your colleagues from Geneva and with a German arbitrator who was a professional mediator. And when we arrived at the hearing, the day of the hearing, the 3 of us, we said, but we don't understand why they have not been able to settle this dispute. And the mediator said, but I can help. And he proposed to the party, we proposed to the parties, after discussion, would you agree for a mediation before we start? And the party said, yes, yes. And the arbitrator organized the mediation, was very, very professional. Of course, he had the skills. And believe me, it was a very big case in the computer industry involving American clients. At midnight, the same day they settled.
Amazing, amazing. Yeah, so that's so interesting. We have 2 more questions. One is from Christina, who asks, do arbitrators need to be more robust in penalizing a party that clearly attempts to derail the proceedings? Very topical issue. In your anecdotal experience, she asks, when did enough is enough, this kind of moment crystallize? What is the most effective way to prevent a party from using guerrilla tactics?
Well, it depends what kind of guerrilla tactics. I think that, of course, the chairman has a role to play and try really to make sure that these guerrilla tactics are not successful. One thing that happens very often is that one party tries by all means to delay the arbitration. You have to resist that. And, so they say, well, it's a violation of due process. Well, you know, this is something, this is a flag which is, you know, raised very often, but when you are an experienced arbitrator, you're not impressed by that. You know, you have to follow your role and your path, and generally there are always ways to make sure that the arbitration is not derailed when there are guerrilla tactics. And of course, you have also the possibility to say to the parties, you know, we will take into consideration your conduct in the allocation of cost.
Mm-hmm. Now, very interesting that you provide the viewpoint from an arbitrator, which of course is the one now where you are so experienced. But I wanted to ask you a related question, taking for the moment the view of counsel. What if counsel is pushed by a client to delay the proceedings? At the same time, now there's all this emphasis on efficiency, and you know, to some extent, I guess all parties and counsel should also have a duty, perhaps, to contribute to an efficient dispute resolution process and not derail or obstruct the proceedings. How do you combine these different, is there a tension there? If you had to advise one of our audience who has this kind of recalcitrant client, how should one behave in these situations?
I think it's also a matter of ethics for counsel, you know, not to follow. You know, I've seen counsel who just resigned. I've seen that several times, counsel resigning because they do not accept to follow their clients. And if they continue, of course, and they try to delay, no, you have to stop that. And so they are asking for the third time an extension, and there is no reason. And they say, well, if you don't give me the extension, well, your award will be fragilized. I don't care. You know, if there is no reason, I continue. I'm not afraid of being unpopular with the parties. Huh?
That's great. I have one final question since we are nearing to the end. I know you are a fan of so-called hot tubbing or witness conferences. Someone from a former collaborator of yours that is in Geneva now and is a friend of mine told me this information. So first I would like to know why you are a fan of witness conferences. Maybe we can explain to the audience what it is. And second, do you use it for both for witnesses, fact witnesses, and experts? And if you have any interesting stories to share.
Yes. I would say hot tubbing is different of witness conferencing. Witness conferencing means that you put all the witnesses together and you ask questions to all the witnesses on claimant side, respondent side. I've seen it done by one of your colleagues in Geneva. It is very, very, very efficient, but generally we don't do it because the parties hate that. You know, they want really to do it their way with cross-examination and so on. And so it's quite aggressive. And certainly you would never do it with American parties, for example. Hot tubbing is something totally different. Well, for legal experts, when there is a need to question the legal experts, I always do hot tubbing. So, for example, I have a case next week in Singapore, and I'm going to do hot tubbing of legal experts. So I've prepared a list of questions after I've read their opinions, both on Indonesian law. I've read their opinions. I've put a list of questions, put them together on the stand. They do not receive the questions before the examination. And then I ask the question to both of them. You know, this is a very, very, very efficient procedure because when they are together, so you have two law professors generally, or very prominent lawyers, they don't want to lose face by saying stupidities. So generally they come closer, and sometimes yes, I said this, but it's might be a little bit different. And generally they tend to agree. And at the end, you know exactly what the law is. So for legal experts, I always do that. For other experts, I think it's also very helpful, but it depends really on the quality of the experts, because sometimes, they have so different approaches that, doing octabbing is not very efficient.
That's so interesting. It's still something that I have seen rarely done, but I will definitely consider this in my future cases, because it sounds really like an efficient approach, especially for legal experts. We have a final question from the chat. Nutsa asks, what's the main personal characteristic that an arbitrator needs? Is it having a good competence, or is that all, or maybe good skills of communication?
Well, I think it's a combination of several things. First, a good common sense. Good common sense. My parents were in business, and I have also a commercial sense of business. I think good common sense, also being able to decide. I see arbitrators, who are always hesitant. As far as I'm concerned, I decide. And that's what the parties want. They want somebody who is able to decide, even if they are not happy with the decision. And of course, yes, of course, competence, good knowledge of the law, and also probably also good sense of communication. Yeah.
Thank you, Professor Hanotiau. I think that was a very insightful session, and I thank you very much for your very straightforward and interesting and thoughtful answers. I think it was very interesting for all of you, for all of the audience, was certainly very entertaining and interesting for me. So Becca, back to you.
Thank you very much.
Thank you very much again. And Michele, if you allow me, if I use this advantage that I have privilege to be online and have the direct access to ask the question, one more question from me, if you allow me. Maybe my question will be related to the provisional measures. How, Professor, do you see it? How efficient this mechanism in international arbitration is, especially when we know that the different institutions years ago they amended the rules, they have the emergency arbitration and so on. We know that the effect of the provisional measures can be very effective when another party doesn't know the result when the measure is used. But on the other hand, you have to go to another national court to make some injections or whatever there is when there is something to be active, so to be implemented, I mean. And these awards and decisions should be enforced by the national courts. So in these terms, how you see, is it efficient mechanism in international arbitration? Fast and efficient, I mean?
Yes, yes. Well, you have to distinguish emergency arbitration and provisional measure. Emergency arbitration, I have done it. I had even a case where we suspended the takeover bid. Well, when I order something in a decision on provisional measure, and I must say that there are more and more and more. I must say, in majority of the cases that I have got recently, there is a request for provisional measures, suspension, request for communication of the name of the third-party funder, security forecast, all kinds of provisional measures. When I made a decision on provisional measures, I always say that parties, we understand that parties are involved in international. The parties are involved by definition in international commerce. Their reputation is at stake, and therefore they should comply with the award, because it's also a matter of ethics, but it's also a matter of reputation, and generally they do, because they know that the case will continue. And if they lose face vis-a-vis the arbitrator because they do not comply with the provisional measure, doesn't start well for the rest of the case.
Thank you very much. Thank you very much. So, Michele, if you allow me, maybe I will shortly thank to all of you, both of you, sorry. And I will say that the encourage to other students, young practitioners, that they should watch this video and look the ideas, advices what the professor has made here, how to enter in the profession, how to become arbitrator, and how patient they should be, and how communicable they should be. So this is really it was a really extremely very, very interesting interview. Thanks, Michele, for that, and of course, Professor. I wish you very nice weekends, and to Professor the very nice flights to abroad. And again, I'm sure that next year I will be able to invite you in person in Georgia to attend in our arbitration days.
With pleasure.
Which has the major event in this region. And I'm sure that next year will be much more better for the sake of the travel and also in other terms. So thank you again.
It will be a pleasure to come, Becca.
Yeah, finally, you always want to participate, and of course, I really say that we will invite you in due course. Thank you again. If you want to say some other words.
Thank you. Yes, thank you very much, Becca. Thank you, Michele, for the interview. Thank you.
Thank you, and also the attendees who has participating and asking very interesting questions.
Thank you. Bye-bye.